Hello, everyone, and welcome back. I accidentally stopped recording, so we will continue on from slide 28. We were talking about community treatment orders. So, a CTO or a community treatment order is a legal order that's under the Mental Health Act, and it allows a person that has a serious mental illness to live in the community while having a structured treatment plan rather than being kept in the hospital involuntarily for an excessive amount of time. So it's a way of really balancing the client's freedom, so to say, with the need for ongoing treatment and safety, especially for those clients that have a history of repeated hospitalizations, right? And they may not be following treatment when they get discharged. So usually with a CTO, it requires the person to follow some sort of community-based treatment plan, and it can last up to 6 months, and then it's renewed with a hearing with the Consent and Capacity Board, and it's issued by a psychiatrist with the patient's consent or the substitute decision maker's consent. And with the treatment, the CTO plan, it usually includes their medication management plan, how regularly they have to follow up with their psychiatrist, if there's any substance use support that they need, even has information about their housing, what other supports they might need. And essentially, it's a plan to ensure that the client is safe in the community and has their rights met, has their freedom, because they're not involuntarily hospitalized, but they're also following their treatment so that we're preventing that revolving door from happening and preventing the client from becoming more symptomatic if they're especially refusing treatment. I think it's the next slide. Yes, so last 6 months. Okay, so refusal with a CTO. So if a patient does not adhere to the CTO's requirements, so if the CTO says that the client has to come in and see their psychiatrist or their community mental health team once a month to get their antipsychotic injection, but the client is refusing, then the physician is able to issue a Form 47, which then allows the police to bring the person to the hospital for an assessment. So, of course, this doesn't mean that, if the client refuses once, you're like, okay, well, you're not taking your medication. I'm going to tell the doctor's going to issue a form, and you're going to be admitted to the hospital again. That's where that relationship building comes into place, right? We, of course, have to take all the necessary steps to understand, well, what is going on right now? Why is this client refusing medication? What are their concerns? What are they fearful about? Are there other circumstances that have led to this unwillingness to participate in their treatment when last month they did show up for their injection, right? So, of course, you have to put in all of those practices into play. And you have to also remind the client nicely and gently that, Mr. Jones, you remember that you are on a CTO. So as per that, it is a legal document. You do need to come in and get your regular monthly antipsychotic injection. Otherwise, the doctor might have to issue a Form 47 and we'll have to bring you into the hospital to get reassessed. So you're being very matter of fact, and you're letting them know that these are the legal requirements, and it's something that you are also bound by the law, as the nurse that is working with them. So there are legal obligations that you also have to follow if the client is refusing their treatment as outlined in this legal document, the CTO. And of course, this doesn't mean that the client is going to require rehospitalization. It's also to determine what the next steps are going to be. Like, has this client deteriorated and maybe their medications need to be reviewed? Maybe their assessment plan, their treatment plan needs to be changed. Like, what are the next steps? So when a client does have a CTO, they have to be informed that they are on the CTO and what the conditions are. They can refuse the CTO if they are capable, and they also have the right to appeal to the CTO. Appeal the CTO to the Consent and Capacity Board. And then the Consent and Capacity Board essentially decides if the client is capable of making this decision or not. So now want to think about the ethical tensions in CTOs. So, as we've mentioned, the community treatment orders are meant to support people that have a serious mental illness by ensuring that they receive treatment while they live in the community. However, they can also be seen as restricting autonomy. So now I want you to think, do you think that CTOs are more about promoting patient well-being or about controlling their risk to society? And how should nurses balance respect for autonomy with the duty to protect? So you might think about principles of respect for autonomy versus paternalism, beneficence, and non-maleficence, and even justice, right? When you're thinking about this. And even from a relational ethics perspective, this type of quote unquote forced treatment or coercive relationship, does this affect the power dynamics between the client and the nurse? Of course it does. How so? Right? Um, that's why we have to think about special considerations that need to be given to the aspects of engagement and mutual respect and the environment and even uncertainty. So think about this. What are your thoughts about a CTO? So continuing on with the rights of the client under the law, beneficence is the principle of acting to benefit others, preventing harm, or even removing harm. And non-maleficence is the principle that obligates one to not inflict harm on others, right? So when it comes to involuntary admission, there is legislation, as we've now learned, under the Mental Health Act in Ontario that enables the legal sanctioned violation of human rights for a person that has a mental illness, right? So this can occur when a client is involuntarily admitted to a mental health facility or even to the hospital. But then you're thinking about all of those principles, right? Even though we're violating the client's autonomy, there are safeguards that are put into place, right? So that we're not inappropriately detaining a person in the hospital. There are still rules and regulations and laws that we have to follow. The client has the right to, speak to a patient advisor, for example. Even the use of least restrictive means of restraints, right, for the shortest duration is always the general rule. And restraints are considered almost like you need an order for it, right, from a physician. And even if a client does have restraints, you have to regularly assess them. That has to be included in that order from the physician as well. Like how often are you checking on them? Is it every 5 minutes, every 10 minutes, every 15 minutes? You have to ensure that the client gets enough food, hydration, they can go to the bathroom. We have to be able to maintain the client's safety and their comfort. And all of this, of course, has to be documented. Guardianship, we've already mentioned. This is when the client has someone acting on their behalf, either a family member or as an SDM or a publicly appointed individual. Rights regarding confidentiality. So, in some situations, disclosure may be mandated to protect the patient, other people, public health. And there are four situations that might warrant the violation of this right to privacy by the nurse. So the first is duty to warn and protect third parties. So this is if there is a potential for suspected harm to another person, um, if there's suspected harm to a child, if there is the potential for harm to the client's self, maybe if there's a suicide risk, and there's the presence of a reportable communicable disease, right? So all of this does warrant also collaboration of treatment and documentation, of course. And for example, if there's a psychiatric client that describes to a nurse their plan to harm themselves or another person, and that nurse fails to report that information or even document that information, rather, including the need to protect the client or the identified victim, the information will be lost when the nurse leaves work, right? If they don't document and they didn't even tell someone, and then the client carries out that plan, that harm that is caused could be linked directly to the nurse's failure to document and to communicate this important information. So, of course, we know documentation is key. If it's not documented, it's not done. But in these particular situations where you feel the client has said and expressed, and you feel that they are a risk to self, to others, you have to definitely document it. And when I said the presence of a reportable communicable disease, I'm thinking about like public health, right? Public health nursing. If there's certain situations like there's say like a West Nile virus, there's TB, like HIV, like syphilis, certain STIs even. There's a protocol that nurses do need to follow. And even confidentiality after death. So just because a client has died, it doesn't mean that you are now able to talk about their personal health information freely. That still remains confidential, even though the client has physically passed away. So now we'll talk a little bit about civil obligations and responsibilities. So when we're talking about tort law, this is a civil wrong for which money damages may be collected by the injured party, which is the plaintiff, from the responsible party, which is the defendant. And under tort law, we have intentional and unintentional. So intentional tort is a willful or intentional act that violates another person's right or property. So this could be assaulting someone else, battery charges, false imprisonment, invasion of privacy, or even defamation of character. And an unintentional tort is unintended acts against another that produce injury or harm, such as negligence or malpractice. So healthcare providers who fail to act in accordance with their professional standards, or if you fail to foresee consequences that other professionals with similar skills and education as you could foresee, then you may be found, responsible of professional negligence or even malpractice. And there are 5 elements that are required to prove negligence. And these are here listed for you. So there's duty. So, as nurses, we do have a duty of care that is assumed when we do go into work. So as mental health nurses, we have the duty to understand theory and medications and how that care is used with clients, whether, working in the hospital or working in the community. So a nurse who willingly follows an incorrect or possibly harmful order is responsible for any harm that results to that client, right? So if you have information that leads you to believe that the physician's order needs to be clarified or changed, or even if you feel that the pharmacy had made some sort of error, it's your duty to intervene and protect the client. Breach of duty, abandonment. So breach of duty is any conduct that exposes the client to any unforeseeable risk of harm. This could be either through commission or omission of acts by the nurse. And abandonment essentially takes place in the absence of accurate, timely, and thorough reporting, and in the absence of follow through of care on which that client relies on it. Cause and fact. So this is, would this injury have occurred without the nurse's actions? Right? So if a nurse forgets to give a client their prescribed antipsychotic medication, and then later that client experiences acute psychosis and becomes agitated and injures another patient or injures another nurse, we're trying to think about the cause in fact. So without the nurse's failure of not giving medication, the psychosis may not have escalated to aggression and agitation. The nurse could be seen as causing this injury, right? Proximate cause is were there intervening actions or persons that actually caused the harm? So a nurse gives a client the wrong medication. Sorry, the nurse gives a client the wrong dose. However, before the medication has any effect, the client's family provides them with alcohol when they go on a home pass. And the client has an adverse reaction and they require hospitalization. So the family's action, which is providing alcohol, could be considered the proximate cause, not the nurse's original error. That's just one example. Lastly, it's damages. So as we mentioned, this is the actual pain and suffering that's caused, and sometimes people can be awarded compensation for damages. So the nurse restrains a patient improperly, and this causes a shoulder injury. The actual damages could be the medical costs for the surgery and the physio. The pain and suffering is what the client experiences. So now they have chronic pain and emotional trauma. Um, there's also the consequential damages. The client can't return to work due to limited mobility, which then leads to financial strain. And then incidental damages could be that the client's partner now loses companionship and shared responsibility of home. So essentially, when it comes to negligence, there are things that need to be considered. It's not just surface level. And I'm sure there's other examples that you could even think about from your own nursing practice and the area that you work in. So, of course, documentation of care. This is something that I'm not going to go over it in detail because this is something that you should already know. Medical records, so we know, it's used by the facility for quality improvement. It can be used as evidence, so be as clear as you can in your documentation about your communication plan. And this essentially is the end of this lecture. Thank you very much for listening. And part 2 is going to be in another video.